Good afternoon, ladies and gentlemen. This is the South Carolina Commission on Disabilities and Special Needs. I'm calling this emergency commission meeting to order. This meeting was requested by staff, and 2/3 of the commission did give approval to have this meeting. Most of our staff is at the South Carolina Department of Disabilities and Special Needs on Hardin Street in Columbia. Unfortunately, due to medical problems, I was unable to drive to Columbia today, but I appreciate you all accommodating me and allowing me to continue to manage this meeting virtually online. I'm going to call the meeting to order, and I'm going to ask Commissioner Robin Blackwood if she would please read the notice of meeting statement.
A meeting notice announcing the date, time, and place of the November 9th, 2022 Emergency Commission meeting was distributed November 8th, 2022 to appropriate media and other groups or individuals who have requested notification. The announcement and agenda were posted at the Department of Disabilities and Special Needs Central Administrative Office and on the website. In accordance with the Americans with Disabilities Act, the public has been notified that accommodations such as interpreters, mobility assistance, or other assistance will be provided to individuals with disabilities and special needs if requested in advance.
Okay. Before you have a copy of the agenda. These will be the only items discussed today in our meeting. I need a motion to approve or to make adjustments or changes to the agenda.
I so move that we approve the agenda as written.
I have a motion by Commissioner Malfris. Do I have a second?
Second.
Commission from Commissioner David Thomas. A second from Commissioner David Thomas. Let's vote. All in favor, please signify by saying aye.
Aye.
All opposed? Hearing none, the ayes have it, and the motion stands and the agenda is adopted. The first thing we're going to do today is we're going to hear some presentations regarding Lutheran Services Carolinas LSC. The first speaker is going to be State Representative Micah Kasky. I'm having trouble saying that today. He's legal counsel for LSC. But prior to that, I do want to read to you all, according to the authority granted to this commission by the laws of the state of South Carolina and by the South Carolina DDSN bylaws and policies, we are not required as a commission to in any way allow public input. However, for purposes of information and transparency, this commission chooses to offer this opportunity for important matters. The rules set forth are as follows. You must refrain from using personal attacks on any commission member, individual SCDDSN employee, or any other persons connected to DDSN. If your presentation involves discussing individuals who are served by DDSN, please refrain from using identifying information such as names, birthdays, and social security numbers, etc. Each presenter will be allowed a sufficient amount of time for their presentation. However, if the presentation becomes redundant or excessive, then the presenter will be required to conclude their presentation within a few seconds. Commissioners, please hold all questions until both presentations have completed. The commission does reserve the right to terminate any presentation which does not adhere to the guidelines set therefore. All right, let's hear from our first speaker, Mr. Kasky. Representative Kasky, am I saying that correctly?
Yes, ma'am. You are Kathy. That's it. Is there anything I need to do to make sure the audio is good, or you can hear me clearly?
We can hear you. Yes, very good.
Thank you, Madam Chair, members of the commission. I appreciate the opportunity to be with you today. And as the chair outlined, I know this is not the ordinary course of things. So I appreciate the accommodation, though. Let me also add, I'm here, though I serve in the State House as a legislator, I'm here in my private capacity as an attorney representing Lutheran Services Carolinas. And so I do appreciate the opportunity to be heard today. Regrettably, and this is part of what I want to communicate to you all as a commission, I don't really know why we're here today. And I don't know why we're here because of a lack of communication with the agency, between the provider of Lutheran Services Carolina and the agency. Unfortunately, in my experience representing Lutheran Services Carolina, so I may say LSC to shorten it, my experience is that communication or non-communication is a persistent and endemic characteristic between the agency and the provider. Just yesterday, after notice was initially sent out at 1:23 p.m., by 2:43, I had emailed general counsel and asked for some indication as to what this emergency meeting would be about. The response I got is, I don't have any additional information to share other than all the documents have been provided to your client. I'm talking with my client. None of the documents seem to be responsive to the question of what is exactly the subject of today's hearing. And so I could outline innumerable examples, whether it's the corrective action plan that's been requested by the department, whether it is the A&E and death report follow-up related to one individual, whether it is with respect to a series of recent audits. I'd be more than happy to respond to those. I just don't know what we're here for. And that, quite frankly, is offensive to my understanding of the 5th and 14th Amendments with respect to due process. We don't really know what we're here to respond to. And that just strikes me and my client as fundamentally unfair and unjust. If there are concerns the department has had, what we have asked for time and again, I have personally outright practically begged for an opportunity to get on the same page. We've been denied that time and again. Again, I'm happy to provide documentation of examples of that. So whatever it is that we're here for today, I look forward to learning about that. If there's an opportunity to respond to that, we'd certainly love to do that, and would ask with all due humility and quite frankly mercy, because we are at your whim, for an opportunity to respond before any definitive decisions are made. That requires another meeting. We've asked for that. But what we fear is that we're going to walk out of here today without an opportunity to respond substantively and fully to whatever has precipitated this need for the emergency meeting. Again, I have comments, but I don't want to waste anyone's time, but would love an opportunity to respond. Again, whether it's a future meeting or in written communication. So thank you again, Madam Chair, members, for the opportunity to be here today, and thank you.
Thank you. You want to hear me? Commissioners, can you hear me?
Yeah, okay.
Okay, we're now going to have Ms. Ann Dalton present, please, regarding legal services.
Good afternoon. You all know me as Ann Dalton. I'm the Director of Quality Management here at DDSN. I may not speak with the same level of eloquence as Mr. Caskey, but I do have an equal level of passion and energy to ensure that services at DDSN are the best that they can be. I believe we all have a shared expectation that the settings and services meet at least minimum requirements. And I think we all have a common goal towards quality services. The administrative standards that we have here at DDSN provide a foundation for the DDSN network of provider agencies. These standards articulate the basic expectations for all providers to ensure that they are qualified and well-trained. They are qualified and well-trained staff, that there are appropriate policies and procedures in place to ensure protections for the people supported, including an environment that meets all applicable laws and a culture that promotes dignity and respect. As a qualified provider entity, LSC has submitted their credentials and provided evidentiary documentation to indicate that they have the capacity to provide the designated services with qualified, well-trained staff, and that those services would be delivered within the defined scope. In other words, they said they already knew how to provide residential rehabilitation at the time that they applied to become a service provider. DDSN is available to provide technical assistance, but our agency does not expect to train a provider on how to do their job. When a provider submits their qualifications to deliver residential rehabilitation, they are saying they have what it takes to successfully deliver that service. Not only does that include an understanding of the care, skills training, and supervision, but also the nuances within that service delivery that requires appropriate assessment, development of a support plan, including determining the need for a person's supervision, areas of training that they need and desire, opportunities to help the person to be supported in the least restrictive environment. Residential rehabilitation is not assisted living, and it is not custodial care. Residential rehabilitation is an active service intended to continuously support the person and adapt to meet their needs. During DDSN's review of Lutheran services over these past few months, it's been revealed that the staff are in fact not appropriately trained or supervised, and they are not held accountable for violations of the agency's policies and procedures. This has been communicated multiple times. You each have a packet before you that includes 5 appendices that outline various stages of communication over the past 5 months. And if Mr. Heskey and Ms. Gauss need an additional copy of that, I'll be happy to provide it.
And I don't have a copy of that here. If y'all don't mind dropping a copy of that on email to me real quick, I'd appreciate it.
Colleen
there,
is
if you
sending
have-
that to you, so it should appear momentarily.
Okay, that'd be great. Thank you.
So what we have found is that physical settings may be cleaned up in time for licensing because there is an advance notice. But when you have an impromptu day in the life visit, the scenario presents a very different picture. The unraveling that we will discuss today began with a complaint from a resident's mother made to their case manager back on June 11th. This person had increasingly difficult behaviors over a 2-week period and ingested pieces of vinyl flooring despite having a 1-to-1 staff person assigned to them within the residential setting. Due to those increased behaviors, Lutheran began reaching out to DDSN in an effort to discharge the person to a more restrictive placement. The placement had been stable, and then behaviors seemed to intensify. Through collaboration internally between quality management and operations, we determined the situation required additional review, and we were able to schedule several ad hoc on-site visits to the residential setting. At this time, there were several discrepancies that were noted and brought to the attention of Lutheran Services Carolinas. Medication administration records, otherwise known as MARs to us. They indicated vital psychotropic medications were not available. They were not even in the home for 2 of the 4 residents that lived there. They were abruptly stopped. And as many of you know, these medications come with a warning. You cannot stop taking them abruptly. They have to be titrated. So as we began to look at this, the meds were stopped. They were not titrated down. Once we brought it to Lutheran's attention and they restarted the medications, they restarted at the former level. So there was no gradual getting the person back up to their previous level. Also noted, the medication error forms were completed, but there was no follow-up by the Lutheran staff to ensure that the medications were brought on site or to address how the issue occurred in the first place. There were discrepancies in the psychiatrist orders and the statement of psychiatric drug review. There was an attestation that the psychiatrist had personally reviewed the medications, but they were not correct. They did not match what was on the medication administration record. No one at Lutheran Family Services or Lutheran Services Carolinas had identified this discrepancy. There was no documentation to indicate that any of the issues found by DDSN had been previously addressed. And there was no acknowledgement by the physician's assistant or psychiatrist that the absence of those medications could in fact be the cause of the increased behavior. Related to this incident and the family's complaint to the case manager, an allegation of neglect was filed with SLED. Lutheran was required to resubmit their administrative review 4 times before they met the minimum requirements for this report. There was ample communication and downright instruction that was provided to the agency to get that report submitted. The observations and discrepancies in documentation discovered in June led to the initial material deficiencies letter on June 24th. That is the first item that you have in your packet. LSC responded to the concerns with a general plan to address training and oversight, which were to be completed by mid-August. LSC submitted an additional improved compliance or corrective action plan on August 15th, with a presumption that their freeze would be lifted at that time. LSC effectively acknowledged their failure to review and remain current with DDSN standards and directives and train staff accordingly. But they indicated their plan was to take 45 days to complete an internal review of their own policies and procedures to ensure they were compliant with DDSN, and then take an additional 90 days to inform and train staff on any newly developed policies. As a qualified provider, I will remind you, they were expected to be compliant on day one of their service delivery. So over the following months and in our quite voluminous communication with Lutheran, a number of concerns were brought to their attention. And I've summarized these primarily in three categories. First, we will address healthcare. The residential habilitation standards require that each person receive coordinated and continuous healthcare services based on each person's health needs, their condition, and their desires. Additionally, the standards require that the residential habilitation provider have procedures that specify actions to be taken to assure follow-up with the physician, nurse practitioner, or physician's assistant. There is a requirement that ordered treatments will be provided. Our review revealed a failure to secure and/or administer ordered medications or treatments promptly or at all. A failure to accurately and consistently document known health conditions or diagnoses. A failure to follow up promptly or at all with physician's recommendations to seek services from a specialist, such as a neurologist or podiatrist. And a failure to follow up on recommendations made by medical professionals. For several people reviewed, there was no evidence that could be found to suggest recommendations from a physician to seek services from a specialist occurred. A gastroenterologist was not consulted when blood was found in the stool of a resident. A gastroenterologist was not consulted for a resident known to have pica behaviors. A pulmonologist was not consulted for an individual who had low oxygen saturation. A neurologist was not contacted when there were breakthrough seizures. Podiatrist was not contacted following an episode of edema. And there were no return appointments to a cardiologist to follow up on an electrocardiogram. For several people reviewed, there was no evidence that the recommendations from the physician were explored or implemented, such as necessary dental care for crowns that were recommended, teeth extractions, simple things like purchasing an electric toothbrush, eyeglasses for someone who needed them to be able to see correctly, preparing meals according to a specified diet for someone who has diabetes. It should be noted that on multiple occasions, there was evidence of physician visits or emergency room visits, but no written account of the visit or recommendations that resulted. There were also issues related to allergies, which are, pretty serious. And often on the outside of the chart, there would be a notation that the person was allergic to ibuprofen, but on the plan, it would state there were no known allergies. Or the physician's note would state they had an allergy to Risperdal, but didn't list the ibuprofen. Numerous examples of that kind of misstep. Lutheran has arranged for the majority of their residents to receive health care from a physician's assistant that coordinates their visits in a mobile unit that sets up in the parking lot of the administrative offices in Columbia. This arrangement does not promote community integration and is in conflict with the home and community-based settings rule. There were a number of issues, as I mentioned, related to medication administration errors. Our licensing standards require that medications, including controlled substances and medical supplies, be managed in accordance with local, state, and federal laws and regulations. Orders for new medications or treatments must be filled and given within 24 hours unless otherwise specified. Staff administering medications must successfully complete a medication technician certification program and receive the appropriate oversight. The DDSN review revealed prescribed medications were not available and therefore not given. Prescriptions for medications and or treatments were not filled or given within 24 hours, and when completed, there was no reason documented when the medication error forms were completed. Medication administration records and controlled substance records were inaccurately or inappropriately maintained. Medical supplies were not included on the MAR, and general event reports were not created each time a medication administration error occurred. For one person, it was determined that there were medications were not given 119 times over a 6-week period. Another 50 times over a 10-day period, 48 times over a 15-day period. The list goes on. DDSN raised serious concerns about the inaccuracies of psychotropic medication review documentation and failure of Lutheran staff to ensure consistency within the medication administration record. As I mentioned previously, staff did not recognize the different documents included different medications or different dosages for those medications. For residential support plans, they are the heart of residential rehabilitation services. These documents delineate the specific care, supervision, and skills training which must be provided to each person in order to ensure their health, safety, and well-being. Residential support plans must be created based on the assessed needs of the person. They must be specific to the person and be current and accurate at all times. They must also be readily available to staff who are expected to provide supports to the person. It does not do anyone any good if the plans are kept in some other location or if they're not kept up to date. Residential rehabilitation plans or residential support plans were not thorough, complete, accurately, or readily available during the DDSN review. Sometimes the plans were written and included another person's name. Sometimes there were multiple specific statements that were included in plan after plan for residents in the same house or other homes. Sometimes there were statements that appeared to be confused among housemates, but they may not have been accurate. There were residential support plans that contained contradictory information or information that did not relate to that specific person. As an example, the person needs assistance with the safe use of cleaning supplies, yet somewhere else in the plan it stated they needed no assistance. They needed assistance to evacuate. Elsewhere it stated they needed no assistance. They have a 30-minute supervision need. Somewhere else it would say they had a 15-minute supervision need. Or maybe it stated they required line of sight supervision while they were eating, but somewhere else in the plan it stated they were completely independent. We cannot expect direct support staff to do their jobs if they don't have the correct information about the people that they are supporting. When plans are not available, it makes it difficult to know what to do. It also makes it difficult to know what objectives the person should be working on or how to respond in an emergency. A staff working in the home needs to be able to reference an accurate document and know how to best support the person to whom care has been entrusted. Lutheran submitted a second corrective action plan on August 15th. Despite the efforts noted by Lutheran, DDSN did not find evidence that the cap had been successfully implemented. On September 21st, DDSN received a call from law enforcement regarding a fatality in a Lutheran home that was suspicious in nature. Following an on-site review by myself, the Director of Quality Management, and a member of the DDSN risk team, numerous policy violations were discovered impacting both the physical operation of the home and compliance with service delivery standards. I can tell you that I have personally been on site to 2 of the homes, and as all of this unfolded, I have witnessed these deficiencies firsthand. In addition, DDSN's Contracted Quality Improvement Organization, which is Alliant, found notable concerns relating to staff qualifications and training and the implementation of residential habilitation consistent with the standards. DDSN has communicated the deficiencies in yet another letter to Lutheran on October 3rd. The corresponding administrative reviews for the death report and allegations of neglect remain outstanding after being returned 3 different times to date, and this is due to incomplete or erroneous information. Given all of the policy violations that I personally witnessed, the report only included 1 policy violation when it was first submitted, and that did not relate to the person's care. You have copies of the compliance action plans and the correspondence related to the administrative reviews there in your packet. While DDSN appreciates the internal review that Lutheran has completed, it is still not clear how Lutheran has evaluated the processes in place that led to the lapse in policy compliance. Thus, we are unsure of any efforts to sustain temporary improvements. In total, Lutheran has submitted 3 compliant or corrective action plans. Each has been thoroughly reviewed, but ultimately rejected by DDSN. As I close, I would like to ask you as commissioners to imagine for a moment that you are in need of services. You're placed in a home with little to no stimulation. There's no artwork on the walls, only staff notices for chore list, weekly menus, and a schedule for doctor's appointments and lab work. You do not have any place to go during the day. There are no work or volunteer opportunities available to you. You have no TV to watch because one of your roommates broke the TV. It was a few weeks ago. We really don't know because staff didn't report it. So you really spend all day waiting for something to do. You have no toilet paper, soap, or paper towels in your bathroom. You have to ask staff to give you a snack because the chips and the cookies and any other snacks are locked away in the cabinet. Your view of the outside world is limited to van rides. Then you're placed on a behavior support plan or even prescribed medications because of your behaviors. This is literally the scene that I witnessed.
Thank you, Ann.
Can I ask Anna?
All right. Let's wait till Janet finishes, okay?
Good afternoon. I'm Janet Priest. I am the Associate State Director of Operations here at DDSN. Based on the preponderance of evidence, information that we've learned over the years or over the past few months about Lutheran, DDSN staff's recommendation is that the licenses issued to Lutheran Family Services be revoked. That is 27 CTH1 licenses and 8 CTH2 licenses.
What were those numbers again?
27 CTH1s and 8 CTH2s. Thank you.
Okay, commissioners, you've heard this information. Do you have questions now for any of those who've been up here?
Yeah, I do. I just wanted to
Okay,
ask
who is that?
Barry,
Who?
Barry members,
Yeah, okay, Barry.
I wanted to ask
What would
Ann,
you like to ask?
Ms.
All
Dalton.
right, Ann, if you'll come back to the podium.
We sent the letter on, mentioned the letter we sent on October 3rd. What date did you say you went there and witnessed the death of the person?
The death occurred on September 21st. I went on site September 23rd. It was an unannounced visit. I was there first thing in the morning as the night shift left.
And I was just, did you say, I was asking the question, did you say that you have reason to believe that the death may have been in some way connected to the lack of care they were receiving?
There has been one arrest related to this death. There was an allegation of neglect report submitted. Law enforcement contacted DDSN to indicate there was the death appeared suspicious in nature. And let me clarify by saying there were 2 coroners that showed up on site. There were 2 vulnerable adult investigation unit SLED officers that showed up, and I believe 2 additional SLED field agents that came to the scene that evening, in addition to multiple investigators from the county sheriff's office. So immediately it was known that this was a unique situation. There was a search warrant initiated immediately and items taken from the home by law enforcement officers. There has been one arrest, and that person was arrested. The arrest charge was neglect resulting in death. There is an ongoing investigation, and there may be additional arrests.
Thank you. I think that's all I have right now.
Madam Chair, is it
Other
possible
commissioners?
to address any of that? Can I have just 3 or 4 minutes?
Hold on a minute. Is it bilingual counsel in the room?
Yes.
Yes.
Constance, is that all right, or how does that work?
It's at your discretion, Commissioner Rawlinson.
Sure, if you'd like, I'll tell you what, I'm gonna give you 3 minutes. How about that, Michael?
Thank you, Madam Chair. Ladies and gentlemen, I think if all I knew about this situation was what Ms. Dayton had said, I would burn it all down and see Lutheran services relegated to the ash heap of history. But what has been presented to you is not, in fact, the complete and total story. She's gone through a number of things and outlined them, not only implicating some sort of insidiousness or bad faith. I would encourage you, to the extent that you actually have our responses to these various allegations, to review those in detail. It is insufficient for the government to simply say, let me see if I got this right. And the list goes on. The list cannot simply go on if you were to meet your burden of proof, or if the government in its administrative capacity is going to meet its burden. I recognize you're sitting in a quasi-judicial capacity to determine whether or not to revoke these licenses. I would simply submit to you that, given the balance of the facts before you, given the lack of information with respect to our ability to prepare for a presentation here, that you take that under advisement, review thoroughly in detail the broad brushstrokes, the insinuations that, oh, there was a search warrant taken and therefore it's completely nefarious. Well, search warrants are required to be undertaken in unfortunate deaths like the one that befell the individual in the Lutheran Services care. And just let me highlight for you, if I could, just run down the timelines we're talking about with respect to these corrective action plans. It began on June 24th as she initiated, it's made it with respect to a request for a corrective action plan. Absolutely no direction with respect to form or substance was provided. It was, hey, address these concerns. 3 weeks later, that deadline was, per the deadline, Lutheran Services submitted. 2 weeks later, DDSN replied. 2 weeks after that, we submitted a second improved plan. So this is where things, as I alluded to earlier, broke down with respect to communication. 2 weeks later, I wrote an email saying, hey, what's going on with that? 4 days later, I followed up again. The response I got from counsel was, we'll respond soon. 2 weeks after that, I followed up again. We'll respond soon again. A day later, DDSN replied, we'll have it finalized soon. A week later, I again had to follow up asking, what is going on here? That, I will say to the credit of the director, begat a quick phone call from her. She didn't want to tell me about the death at the time. I understand. So I had to go back to my client. Let me tell you, as a lawyer, that's one of the worst situations to be in when your client hasn't had a chance to communicate yet this incident, but I get it. I'm the lawyer here in this situation. Nonetheless, 2 weeks later, after that, we get the rejection of that second submission, the submission that we had brought on August 15th. So if anyone here is not communicating, it is in fact DDSN, because after they rejected that second version, they asked for a third version. We gave that to them. And I guess today is the first time I'm learning that that was rejected. She said there've been 3 plans that have been rejected. We've submitted 3. I haven't heard any communication as to the third. So I get it. I'm out of time. You don't want to hear from me. You don't want to hear more facts about the situation. Thank you for your service, and I appreciate your time.
Wait, let me ask you one question.
I think we can give
One
it.
question. I have a question for you. If this were your child, would you feel comfortable putting them in that home in Darlington County? Where the
With
boy
all
was
due
got
respect, I'm not
killed?
in a position to answer the question with respect to the specifics of that particular instance, because of that particular home. I can tell you based on my review of that, I'm confident that Lutheran Services has responded and acknowledges that mistakes have been made. There's no question about that. There are no question that problems have happened, but whether or not I put my child there, I can't answer that. And quite frankly, I would also encourage the commission to consider its role as a holistic manager. And whether or not its obligations are being fulfilled for the entire system, and taking a moment in isolation, I think is a bit unfair.
Have you
Okay,
understood?
that's great.
Chairman David
Commissioner
here. David
Mr.
Thomas
Thomas.
here.
Yeah.
I have some
Thank you.
pictures which we also submitted in our most
Wait a
recent.
minute.
Yeah.
I'm sorry. David, Dr. Coher.
I'm sorry.
Dr. Coher had a question, so he's asking his question, and then,
Okay,
Yeah.
thank you.
yeah, I know it's hard.
He's not been there. That was the answer.
I have not been there. The pictures documenting are included in our third corrective action plan.
What's your question, Dr. Coher? I'm
I
sorry.
was asking if he'd been to the facility himself.
Okay.
Okay, David, you can go ahead now.
All right,
might have a question.
the question I have, if we could get, legal staff to take the podium for just a minute, let me ask some questions about administrative procedure, if I could, please. Do we have,
David,
yeah,
if it's regarding our legal advice, we're going into executive session here in a minute to have.
I understand that, but the
Okay.
question arises that should be a public question as to
Okay.
what is the procedure on withdrawal? That is a
Okay,
general
that's fine.
question I'm asking.
That's good. Okay, I just wanted to make sure you knew
Okay.
that we were going.
I
right, go
understand
ahead.
completely.
Counsel?
All right, who do we have from legal staff?
Commissioner Thomas, this is Constance. If you're referring to
Hey,
procedure
Constance.
as far as appeals rights, if the commission were to take an action today, there is a policy that states, and I forget the policy number.
67.
16701 is a BDSN directive, and it does give any provider whose license has been revoked an appeal right. And that process is outlined in that directive. So there is an administrative
Okay.
process for.
Okay, all right, let's take a step. That's a step in case we took an action to revoke the license. Back it up just a second, and discuss with me what the procedure should be, because the attorney has brought up some issues concerning their fair right to hear, and it's a back and forth, so forth and so on. This is the first time we as a commission, at least me, I have not heard this before. I heard something, but I some rumblings, but did not know it was this far down the road. as far as Constance, as far as any entity that has a license, that has privileges and receives money, what is the procedure that the commission is supposed to take by way of a full and fair hearing?
So there is not a process for a hearing. The process is if the commission takes an action, the commission votes to direct the agency to take an action, then the appeal is the procedure. That is the administrative procedure that is allowed. But there's not like a full-blown hearing that could be, it's not a quasi-judicial position that the commission is in.
All right, so it's your take on it then that, I mean, my first inclination is to hear everything, I mean, that has been presented so far. But apparently there's a lot of counter back and forth that will take more than 30 minutes or 45 minutes to examine. My inclination is to meet again with the ability of everybody to. I don't even have any documentation that I have had time to go through. So my instinct, and I'm a lawyer too. My instinct is to say, hold it before we take any action for any agency that has a license. And if the issue is revocation, then we need to initiate a full hearing, whether or not that's called for or not. Now, I'm speaking not so much to Constance, but the other commissioners at this point. And I'd like to get others' take on that before we go into an executive session. I want to understand how we're approaching this procedurally to give everybody a full and fair opportunity to be heard. However, the nature of this is an emergency. Other lives may be at stake. And so I'm trying to balance these two concepts. And so if we did do another hearing, it would have to be done quickly and set aside, a couple of hours to hear some testimony. So that's it, Madam Chairwoman. And I hope I've made myself clear. I'm hesitant to run to the end zone when there may be, we need to dot some I's and cross some T's before we cross the finish line.
Okay. And I think too, we have to receive legal advice and counsel, in private, in our executive session, just to know what our legal obligations are too, as well. So, okay. Is there any other questions?
I just have a question for Attorney Cassidy. When did your law firm learn of this incident?
Which incident, sir?
The death.
The death, I learned that evening, which was September 21st. I had received a follow-up phone call to my inquiry about the status of our CAP from the director. She called me and said law enforcement had responded to the scene and that I should call my client, which is the ultimate trump card to play on a lawyer, let me just tell you. But then I learned in a phone call subsequent to that about the death.
So what action have your law firm taken since your learning of the incident?
So I represent them in their capacity as effectively general counsel. I think is probably the best way to conceptualize it. So what actions have I undertaken? It is to communicate, direct, and counsel the client with respect to the development of its responses to the agency's inquiries. We've attempted, for example, to ask about the findings of the investigation, which we were told, asked the agency, law enforcement has asked DDSN to not share any information due to pending investigation. They didn't give us anything. When I reached out to the sheriff, they didn't either.
As a general counsel, were you ever in touch with SLED?
I have not been. My understanding is that I want to be clear not to conflate separate instances. There were some earlier allegations of abuse and neglect that really got this all going. Those were unfounded. The investigation, because of the nature of the characteristics of the deceased, SLED was called in, their special victims unit, that's not what they call it, but it's effectively that. But the charges were made by the Darlington County Sheriff, and those remain pending.
But I just wanted to know, have your law firm been in touch with SLED any way, any shape, any form
No, sir.
in reference to this?
No, sir. I've had no communications with SLED as it pertains to Lutheran Services Carolinas.
Thank you. All right, any further questions?
Commissioner Rollinson, if I could clarify
Yeah.
something related to the policy directive that governs the license revocation.
Please do.
I think we have counsel here going back and forth, which certainly makes this feel like an administrative hearing, but it is not one. It was an emergency meeting for the staff recommendation for this matter. The way that policy directive is drafted, it really gives the director of quality management the discretion to bring this recommendation. And the staff position has been that the back and forth starting in June, which you all have copies of. And yes, there were multiple different responses to different caps. That has been the opportunity to demonstrate capacity and respond to the concerns. And it was after review of the third cap and ability to reasonably design transition planning that we brought it to you in an emergency state out of concern for the health, safety, and well-being of those served. But I did think that because we have attorneys presenting, it starts to make this look like it's an administrative hearing. It is not. That is an entirely different process. And this does contemplate an appeal process, which would have the administrative proceedings and all of those, due process rights and full opportunity to be heard as part of it. And perhaps counsel wants to clean me up a little bit, but I just think that I don't want to give the appearance that we're giving half of an administrative hearing. This is not an administrative hearing.
Okay, that helps a little bit. All right. Commissioners, are there any other questions? Are you prepared to move into executive session?
What you're basically saying is that what David was speaking of is truly the next step after they would appeal. Is that correct?
That is correct. That's what I'm saying.
Okay.
Okay. Are we ready to move into executive
What I
session?
just said, I said it kind of low.
Repeat that, please.
I just said that what David was speaking of is actually would occur in the next step, which is an actual appeals process if they were to do that. So, so we would give them full right, as we should, to give their story, and I'm happy that he's here today to try to clarify as much as he can. The only thing I would ask is, when we go into executive session, would Mr. whatever your last name is, Caskey, like to give us any other 1 minute, literally 1 minute summary of before we go into executive session?
Thank you, Commissioner Malthus. If it's all right, the chair, I was going to say this. There are individualized responses to individualized allegations in your materials. As the one commissioner who's weighed in remotely, this is a complex matter. And all we're asking is to examine that information fully yourselves. Look at everything that is there. Clearly, there's some acrimony between the parties in here. And what I'm concerned about is not that this is an administrative hearing, but that insofar as you are going to take some executive action that will cause immediate economic harm to an organization with whom you have a contractual relationship, take the time and look at the materials. If there are questions, we're happy to respond. I have begged for meetings along the way. It's on the cover sheet of the email because I happen to draft the letter accompanying the third cap. And lastly, if this were an emergency, we should have been talking about this in June or July or August or September or October. To imply that it is now an emergency, I think does a disservice to the word emergency.
Thank you.
Okay, thanks, sir. All right, commissioners, do I have a motion to move into executive session?
So moved.
I have a second?
Second.
Motion and a second to move in executive session. All in favor, signify by saying aye.
Aye.
Opposed? Seeing none, we will move into executive session. I will sign off of this session and sign back on to the one downstairs. And we will go into session for a few minutes, okay? And the purpose is to receive legal advice regarding contractual matter regarding Lutheran Services of the Carolinas. I'm going to call us back to order. The commission is rising out of executive session. No action was taken, no votes were taken. So we're at the pleasure of the commission. Does the commission have anything they want to address?
Madam Chair, I have.
Yes, Mr.
I have
Yes,
two
Mr.
motions.
Yes, Commissioner Miller.
I have two motions.
Yes, sir. Let's take them one at a time, please.
Thank you.
Okay, first motion. I move to accept staff's recommendation to revoke all licenses for Lutheran Services Carolinas, which includes 8 licenses for CTH2s and 27 licenses for CTH1s.
Okay, commissioners, you've heard the motion. Anyone need it repeated? Do I have a second for the motion?
Second.
Motion and a second on the floor. Is there any discussion regarding this matter? Hearing none, all in favor, please signify by saying aye.
Aye.
All opposed? Hearing none, the ayes have it, and that motion does carry. Now, Commissioner Miller, you have a second motion.
Yes, I do. I move to terminate Lutheran Services Carolinas contract with South Carolina Department of Disabilities and Special Needs for the contract period of July 1, 2022 through June 30, 2023, based on Article 5, Section B and Section C of the contract.
Thank you, Commissioner Miller. We have a motion on the floor. Do we have a second?
Second.
I have a second. Motion and a second on the floor. All in favor, please signify, or excuse me, is there any discussion on the matter? Hearing none, all in favor, please signify by saying aye.
Aye.
All opposed? Hearing none, the ayes have it, and the motion is approved. I believe that is everything that is on our agenda for today. We will adjourn until next Thursday for our regular DDSN meeting. Thank you and have a good day. I need a motion to adjourn.
Moved.
Second.
Motion is second. Okay, we're adjourned. Thank you, gentlemen.